So good afternoon, everybody, and welcome to our webinar on the murder and its defenses. I am Dr. Charu Mathur, an advocate on record with the Supreme Court of India and editor with the ebclearning.com. EBC, this webinar is brought to you by ebclearning.com. EBC Learning is e-learning educational initiative of Eastern Book Company, the leading law publishers, and those who brings us the journal SCC, Supreme Court Cases. Today with us, we have Mr. Shakil Suri. I welcome Shakil. So as you know, this is the second part of our series. We will be having a continuous series on the murder and its defenses with Mr. Suri. Mr. Suri is a seasoned lawyer of the Supreme Court. He has conducted many murder appeals in Supreme Court as well as various high courts. He is educated at LSE as well as the Wharton Business School in US. He has initially trained with Mullah and Mullah, and today he is with his own firm, Suri and Suri, leading advocates on record firm as well as counsel firm in the Supreme Court of India. Now, just to tell you a bit about the webinar itself, we will be covering about the various aspects of the murder cases. In the previous part 1 series, we have already covered section 299 and 300. We have started covering that, and we will be going in more and more detail as we plan to cover this entire gamut. It remains still a puzzle what amounts to culpable homicide, when it amounts to murder, and when it doesn't amount to murder. Now, this video is available to you on the YouTube also. It is live streamed there. And apart from that, the first part I'll suggest it is available on the YouTube. You go and watch the same part in the email that we have sent to you in the flyer. We have already given you link to his previous, right? And right. And so over to you, Shiki.
Thank you. Thank you so much, Charu. It's always a pleasure to be back, and I look forward to hopefully solving the puzzle this time. So we saw last time, that the law of murder is contained in 4 sections. That's section 299 to 304. We try to understand what is culpable homicide and what is its punishment. We discussed when is culpable homicide murder and its punishment. So we also discussed the exceptions that are provided under section 300 IPC, and what is the punishment when the case fits into one of such exceptions. So the last session also provided insights on how you would approach preparation for your matter, or how you would approach a matter when your matter is listed before the Supreme Court if it's a murder matter. And we also shared tips on how to present your case at the initial admission stage and at the final hearing stage. We also discussed, or rather explained this with reference to some Supreme Court judgments. So today the idea is to look at these provisions again with some more examples and try and see if we can solve the puzzle which Charu mentioned. I mean, we're going to try and do that with some illustrations, with some exercises. So the way I plan to do it is sort of break up this 45-50 minutes that we have into 2 parts. So the first 20 minutes, we'll try and go through the provisions again. So this is for the benefit of people who attended last time, as well as people who are attending for the first time now, so that we are all on the same page as far as the provisions are concerned, and the basics of 299, 300, and then the punishment under 302 and 304. So the first 20 minutes, we'll try and do that. The next 20 minutes, we've put together 4 sort of illustrations for you. And these are facts which we put together basis some cases and some illustrations that are part of the code. And we'll put these illustrations on the screen, and I'll encourage all of you to sort of try and solve this puzzle along with me using sort of the basic principles that we discussed last time and what we will discuss today, and see if we can arrive at an answer as to whether it is murder, whether it's culpable homicide, or as to what would the punishment be. So it'll be, I think, an interesting exercise which we'll try and do. I have 3 or 4 examples put together. We'll share that on the screen, and we'll try and solve those questions. So So we'll spend 20 minutes on that. And then I want to leave some time. I think the remaining 10, 15, 20 minutes I want to leave for questions and questions that Charu, you may have, or the audience may have, so that we can complete the loop on the basics of 299 and 300. And in the next session, we can then move along with other statutory defenses that we want to explore. But the idea is to close the discussion on 299 and 300 today with some recap, with some examples, and then some question answers, hopefully. Yeah?
Right.
So now I'm just going to, Charu, share my screen for everybody's benefit, so that this is the chart we had last time, which we had put on the screen. So just to understand the distinction between 299 and 300. So Charu, you can see the screen, right?
Yeah, I can see it.
Okay, so hopefully everybody else also can see the screen, and has this chart in front of them. So section 299 defines the offense of culpable homicide. 300 deals with murder, although there is, like we discussed last time, there's no clear definition of murder in section 300. So when a culpable homicide is murder, then the consequences follow under 302, which we saw last time.
Right.
Right? And where an offense is culpable homicide not amounting to murder, punishment would be under section 304 of the code. And punishment under 302 is either life or death. And under 304, part 1, it could be life or up to 10 years. And in part 2, it is up to 10 years. So there's that distinction which we saw in the punishment between 302 and 304. So if it's a culpable homicide under 299, punishment is under 304, which is a lesser punishment. If it is murder under section 300, then the punishment is under 302. So the attempt always will be that if you've been, if it is a case of murder, of course, your attempt will be to seek an acquittal. But if you're not able to succeed as far as acquittal is concerned, then you try and place your case under 299, so that under 299 and 304, so that you are entitled to a lesser punishment. So that was one takeaway which we tried to sort of take away last time. So now just looking at this chart and trying to compare and see what is the difference between culpable homicide and when is culpable homicide murder. So if you see this chart, now the first part of 299, which is clause A, as well as subsection 1 or clause 1 of 300, both deal with intention of causing death. So that is the commonality between 299 and 300. So like we mentioned last time, if there is an intention of causing death, then it is a case of murder. An intention, we saw, could be determined basis several sort of factors. It could be basis the injuries, the number of injuries, the body part on which the injury is inflicted. So for example, if it's inflicted on the head, so intention could be deciphered basis some of these factors. So if there is an intention for causing death, then it is a case of murder, and that you see between 299A and clause 1 of 300. So that's the common part of 299 and 300. Now look at B and look at clause 2 of 300 now and read it. So with the B, with the intention of causing such bodily injury as is likely to cause death. So underline the word likely. So in 299, in the case of culpable homicide, it's the likelihood. Whereas in section 300, it reads with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. So in this, you underline the word knows, and knows is for knowledge. So knowledge here, and we're trying to distinguish, we're trying to make a distinction between B and clause 2 and then with clause 3. So knowledge under 300 is awareness, which we discussed, of the consequences of the act. So say, for example, if you are aware that the deceased, the person whom you've attacked, is of a particular age, or is facing, or is suffering from, let's say a special circumstance, and you have knowledge of that. And if you attack him and that attack leads to his death, then that knowledge part will come into play. So if you have knowledge of a particular circumstance which the deceased is suffering from, this comes into play. Likely is, if it's a uh, the word likely is with respect to a probable cause, but clause 2 here deals with knowledge. So if you are aware of a particular circumstance, like the age or a particular circumstance with respect to the deceased, then it will fall under um, clause 2 of 300. So these two parts are, so 299, intention of causing death, small a, clause 1, intention of causing death. In both scenarios, it will be a murder if there is an intention of causing death. That I think is very clear. Then as far as intention of causing bodily injury is concerned, then we read B along with 2 and along with 3. So B, 2, it will be a culpable homicide where where you have the intention of causing a bodily injury, which will likely cause death. It will be murder if you have an intention of causing bodily injury, as you would know, would likely cause the death. So the difference here is knowledge. So if you can say you did not have the knowledge, you could make your case fall under 299. But if knowledge is imputed to you, then it falls under 2, and it would be a case of murder. Now let's read 3 and B, clause B of 299 and clause 3 of 300. 3, with the intention of causing such bodily injury to any person, and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. So in 3, you mark the word sufficient, right? Both clause 2 and clause 2 and clause 3 have the aspect of intention, which is the heading which you see. So both have the intention of causing such bodily injury. But in 3, what is also added is the fact that the injury that is inflicted is sufficient in the ordinary course of nature to cause death. Yeah. So as far as this is concerned, we saw the illustration which is appended to section 300, which says that A intentionally gives a sword cut or a club wound sufficient to cause the death of a man, and Z dies. So A is guilty of murder, although he may not have intended to cause Z's death. So even though he may not have had the intention to cause death, but because the injury that A caused to Z was sufficient to cause his death, it will be a case of murder. Now, as far as 3 is concerned, the prosecution has to prove the injury. They have to prove the nature of the injury. They have also to prove that it is intentional, meaning thereby that it was not accidental or unintentional. So that is a burden which is on the prosecution. Now 2 and 3 seem to be slightly confusing or look similar, in some aspects. So what is the difference between clause 2 of 300 and clause 3 of 300? So for that, we looked at illustration B under section 300. So the illustration B reads as follows. A knows that Z is laboring under such a disease that a blow is likely to cause his death. A knows that Z is laboring under such a disease that a blow is likely to cause his death. So knows is equivalent to knowledge. So he knows that Z is laboring under such a disease. So he is aware of a particular circumstance which Z is suffering from. Therefore, even though the blow that A causes may not be sufficient to cause his death, but because A knows that he was suffering from such a disease that such a blow would cause his death, it will be a case of murder. So again, it is murder, although it may not be sufficient to cause his death. So again, I'll try and explain the difference again. So the difference between clause B of 299 and clause 3 of section 300. So clause 2 and clause 3, I think the difference should be clear with that illustration. Now the difference between clause B of 299 and clause 3 of 300. Here the difference is with respect to the probability. And we discussed this last time. If death is the most probable scenario, then it's a case of murder. If it's a likely scenario, you could place your case under 299. Now, so this is as far as intention is concerned between 299 and 300. So this is the distinction between intention. Now, the second part of both 299 and 300 deals with knowledge. So 299C, clause C, with the knowledge that the act is likely to cause death. And in 4, with the knowledge that the act is so imminently dangerous that it must in all probability cause death or such bodily injury as is likely to cause death, and commits such act without any excuse for incurring the risk of causing death or such injury as is mentioned above. And we saw this illustration last time, illustration D. A without excuse fires a loaded cannon into a crowd of persons and kills one of them. So here, A would be guilty of murder even though he had no intention to kill that particular person, but he had knowledge of the result, and he had knowledge of the risk that is being taken, that such an act is likely to cause death. So therefore, it will again be a case of murder. So, and let me now outline again what the step-by-step approach which we outlined last time. So the first step that you take is you make your analysis whether it is a case of culpable homicide under section 299. If the answer is yes, then whether it is murder under 300. If the answer is no, then as we discussed, the punishment is under 304, part 1 or part 2. And of course, if the answer is yes, then the punishment is under 302. The second aspect we dealt with were the exceptions under section 300. So if your case falls under any of the exceptions, the offense would be culpable homicide not amounting to murder. It will be an offense, culpable homicide not amounting to murder, and would be punishable under section 304. So the second aspect we discussed was to see if your case would fall under any of these exceptions that are there under section 300. So I'm going to quickly run through the exceptions. We won't spend much time on the on the exceptions, reading the exceptions, but we'll focus on exception 1, exception 2, and exception 4, which are most commonly used. So exception 1, as we saw, deals with a case where there is grave and sudden provocation. And if you're able to fit your case, like we discussed in any of the exceptions, then it will not be a case of murder, but will be a case of culpable homicide not amounting to murder. And this exception has certain exceptions in the exception itself, which we saw last time. Exception 2 is with respect to the right of private defense in good faith. But what is important in exception 2 is that that right of private defense should be exercised without premeditation and without any intention of doing more harm than is necessary for the purpose of such defense. So exception 1 is grave and sudden provocation. So if you've suffered from grave and sudden provocation, and like we discussed, it's always a question of fact whether the provocation was grave and sudden. And the test we sort of laid out last time is, would a reasonable man lose his self-control? Would he have retaliated in such a manner? And the landmark case on this was the Nanavati case, which you are all aware of. For exception 2, it's very important that when you exercise the right of private defense, it has to be without premeditation and without any intention of doing more harm than is necessary. So if the prosecution is able to show that your attack was premeditated, then you would not be able to take advantage of private defense. If they are also able to show that you have done more harm than is necessary for the purpose of such defense, then again, this exception is not available. So another example for this we gave was that when you are exercising, let's say, your right of private defense, and somebody's attacked you and you've attacked the person back, but you continue to assault the person even after, let's say, that person has fallen down, then you have done more harm than is necessary, and you exceeded the right of private defense. So the right of private defense would not be available. Now, exception 4 is we discussed all the ingredients of section 4 have to be available or have to be brought out for you to take benefit of exception 4. Exception 4 deals with the case of sudden fight, but that sudden fight has to be without premeditation. So again, premeditation is very important in murder cases. So if the prosecution is able to show premeditation in any form, then you will have a difficult task taking advantage of these exceptions. So no premeditation, sudden fight, in the heat of passion, in a sudden quarrel, and again, without the offenders having taken undue advantage or acted in a cruel or unusual manner. So again, it can't be the case that if there was a fight, if you are able to satisfy that, look, yes, there was no premeditation, it was a sudden fight, it was in the heat of passion, upon a sudden quarrel. But if the prosecution again is able to show that you have taken undue advantage or acted in a cruel manner. So cruel manner has been held to be, by our court, something which is barbaric, torturous. So you have to see that you don't exceed the right that is available to you in the case of exception 2, and in 4 it should not be the case that you have taken undue advantage of that person even in a fight or acted in a cruel or unusual manner. We also saw that, so now 1 and 4 again look very similar, but just very briefly, just to sort of understand the difference in a very simple manner. Of course, these are complex issues, but if you have to simplify 1 and 4, 1, I think, is a case of unilateral provocation by the deceased. So if there is provocation by the deceased unilaterally, then case of exception 1. If it is a case of mutual fight, mutual provocation, where two people are in a fight, then a case of exception 4. So that's a simplistic way of trying to distinguish, but something which has helped me sort of keep the distinction, and something which you could use as well. So I think with this recap, Charu, I think with this recap, I think for people who attended last time and people who are attending for the first time, I hope the distinction is sort of brought out, and we could possibly move to the illustrations which we have set out, which I wanted everybody to sort of take a shot at and see if we can apply what we have learned or sort of seen in the last session, in this session, to see if we can come up with a answer to these questions. So Charu, what I'm proposing is that we read out this illustration,
Right.
give a few minutes to everyone to apply the analysis which we have discussed, the distinction between 299 and the distinction between 300. Try
Right.
and apply that. Look at the exceptions. So what we do is we have the facts in front of us. We try and see if it is a case of culpable homicide, number one. So see if it falls under 299. Then we see if it falls under 300. If it falls under 300, then we see if any of the exceptions are available to us. And then I was thinking of encouraging everybody to on the chat share their answers just to see if how we are doing, how our viewers have sort of are understanding the concept, and then I try and explain what the how our courts have dealt with these factual scenarios. Is that okay, Charu?
Yeah, absolutely. I mean, that's the right way to go about it. So
Okay.
whatever queries you have, you can just type it in the chat part.
Right. And I
Right.
can also, I think I will have access to the answers. So we could potentially, I could also see the answers, and we could give a few minutes for each query. We have 4 here. So let's give about, let's say 3 or 4 minutes for each query and then discuss that. So let's start with the first one. So the first illustration that we have, if all of you can read this with me. A has gone hunting and shoots an animal with an intent to kill and steal it. A ends up killing B instead.
Shakil, I
Who's
think you have to change that document. You are right now sharing the previous one.
also the other one's not coming up?
No, no. You have to please
Okay,
do
so
that.
probably I'll have to stop the share and then try again. Yeah.
Yeah, then you have to reshare.
Okay. Now do you have that?
Yeah.
Okay, good. So yeah, A has gone hunting. So I hope everybody has these illustrations. A has gone hunting, and I would encourage everybody to take an attempt at doing this. There's no difficulty if you get it wrong. I get it wrong all the time, but the idea is to try and sort of break the whole analysis which we've discussed and apply it to these examples and take a step-by-step approach. I mean, there's no difficulty if we get it wrong. That's all right. We are going to keep trying till we at least. So the idea is to get the. It is important for us to understand how we analyze the factual scenarios. Ultimately, if we get it right or wrong, that's shouldn't really matter. What should matter is the way we do our analysis, and let's do it step by step. Let's do it patiently. Let's not rush into coming to a conclusion that it was murder or not a murder. Let's try and use the step-by-step analysis that we discussed. So A has gone hunting and shoots an animal with an intent to kill and steal it. A ends up killing B instead, who's behind a bush. So now the question is, what would A be guilty of? Is he guilty of culpable homicide, not amounting to murder, or would it be murder? So the way to do it is, again, like we discussed, see whether it is a case of culpable homicide under 299. If your answer is prima facie yes, if your answer is prima facie yes, and you look at A, you look at B, you look at C of 299, and try and apply small a, small b, small c. So you'll see if it falls under A, if it falls under B, if it falls under C. If it falls under any of these, then you will move to 300. And then you will apply clause 1, clause 2, clause 3 to see where you would fall. And of course, I think then we are very clear. If it falls under 300, punishment is under 302, which is life or death. If it falls under 299, the punishment is under 304. And then again, another set of analysis is the exceptions under 300, which we can apply. So now let's try and do that. Let's try and see whether it is culpable homicide under 299, prima facie yes, then whether it is murder under 300. So I'll give you a couple of minutes to answer these questions. Use your chat box to send in your answers, and also try and give your reasoning as to whether it's 299 or 300. So try and give your reasoning as well on the chat box, so that we can see your answers and what your reasoning behind the answers is. So let's take a couple of minutes. It's 12:37. We'll discuss the answer at 12:40.
I think you can read the answers as well.
Yes, I think we've gotten some answers.
Quite
So now, yeah. So now, although A is doing an unlawful act, I mean, he's gone hunting and shoots an animal, he is not guilty of culpable homicide. And why is he not guilty of culpable homicides? Culpable homicide. Number one, if we look at small a, there was no intention of causing death. So he had no intention to kill B or to cause death by doing an act that he knew was likely to cause death. So both these aspects are missing. And therefore, it is not a case of culpable homicide. Now compare this to the example which we discussed where A shoots, with a gun where there's a crowd of people and kills one of them. In that scenario, A is guilty of murder because even though he had no intention of causing death, but his case would fall under the knowledge aspect, which is 4, that he was aware of the result and the risk and the callousness that his act is likely to cause death. So that's the difference. I hope that has helped sort of clear, at least as far as the intention aspect is concerned.
Right.
Now, going to the second example. A attacks the deceased at night. So the deceased has multiple injuries on his hands, legs, and ribs. One injury on the head. The weapon used is an axe and a spade. So again, the question is whether it is a case of murder or culpable homicide. And again, the way to do it is, was there an intention to cause death? Then You apply secondly of section 300. Was there an intention to cause such bodily injury as the offender would know is likely to cause the death? You can also check in these facts whether he had knowledge of any special circumstance which the deceased was facing. Then apply thirdly, if it is done with the intention of causing injury and that injury is sufficient in the ordinary course of nature to cause death. So apply 1, 2, and 3 and see where your analysis takes you. And this is an interesting one because, like we discussed, intention is deciphered. This is the factual scenario. And given that there is an injury on the head, that gives an indication that there was an intention, but the court dealt with it in a different manner. And that is where the distinction will become very clear. So again, he attacks the deceased at night. So it's night time, multiple injuries on the hands, legs, and ribs, one injury on the head. Weapon used is an axe and spade. So weapon, nature of the weapon, nature of the injury, the body part, all these are to be considered to see whether there was any intention. So now let's try and get answers to this question, whether it was murder, whether it is murder or culpable homicide. And this is a decided judgment, decided case law by the Supreme Court. And I'll give you the citation in a couple of minutes once we've sort of done our analysis. And I'll encourage everyone to send in their answers because that will help you make that analysis, share your answers, give your reasonings.
Some answers have started pouring in.
Yeah. So I'm Charu. I'm actually looking at the answers as well,
Yeah.
and it does appear that I think the viewers are making that analysis as we have discussed. I mean, it's interesting. I'm actually happy to see that they are applying what we discussed and breaking it down and not reaching a conclusion straight away that it's murder. So they're trying to break it down into 299, 300, and using uh, first, second, third of 300 to give their answer. So that's good to see. And with Zoom, you really don't get the benefit of the audience participation, but I thought this is a good way to get some responses, reactions on whether what we are discussing is actually going through. So, uh,
Yeah. Engaged audience is always an encouragement.
yes, and this I think is an interesting exercise because think once you've done a few of these, at least the basics are in place, and then the idea is for everyone to keep sort of reading judgments of the Supreme Court to understand different factual scenarios, because all these cases are fact specific, and try and sort of cull out the principles which weighed with the courts. So I think just pushing along now with the answer to two. So this was a case where the trial court and the high court convicted the accused under 302. So they treated it as a case of murder under falling under 300 and punishment under 302. But when the matter reached the Supreme Court drew a very fine distinction. So, although the injury was on the head, there was only one injury. What the Supreme Court said was that all the other injuries are all on non vital parts. So, what they said was that it cannot be said with certainty that any particular injury was intended. What weighed with the court was the fact that it was nighttime, the fact that there was one injury, and the fact that it could not be stated with certainty that the accused intended to cause the injury on the head. So the time of the attack was given a lot of weightage in this matter. So ultimately, the conviction was altered from a one to from one under 302 to a conviction under 304 part 1, and that, like we discussed, has been sort of the theme flowing through our sessions, is to be able to make that fine distinction. Again, your first reaction always is that, look, there's an injury on the head, the weapon that is used is an axe and a spade, so therefore you could impute intention and should be a case under section 300. But the distinction was made, one, because of the timing, and second, in the facts of these cases, even though an axe and spade were used, but what the Supreme Court found was that only the handles of the axe and the spade were used. So it drew out a fine distinction to make the difference, to make the determination as far as intention to cause death is concerned. So that is what our attempt should be, is to be able to make that distinction as far as the intention is concerned of the accused. So again, if this is confusing, then it's all right. But that's the whole idea of this exercise, is to be able to make that distinction. And the more of such examples and more of such judgments we read, this will keep getting clearer. Now let's quickly go to, we have two more left, and we have only 10 minutes left. So let's quickly go to our next one and try and answer three, and then we'll quickly do the fourth one. So now, taking a cue from second, keeping the principles of two in mind, now read three. One blow of a stick given again during night time on the head. Question is whether, again, case of murder or culpable homicide. Punishment, I think we should be clear now, whether it's under 302 or 304. Again, one blow of a stick given at night time on the head. So again, there's only one blow and it's given during night time. So let's quickly get the answers and let's quickly run through this because this is quite similar to what we saw under 2. All right. So again, this is pretty straightforward. Again, this was a conviction by the trial court and high court, again under 302 murder, but Supreme Court altered it to a one under 304. So what again weighed with the court was the timing, that it happened on a dark night, and again that it could not be stated with certainty that the accused intended to cause injury. So again, although it's a single blow, you could say it's a heavy or a dangerous weapon, and the blow is given on the head, so it would make a case for murder. So that could be the first reaction. But again, we have to sort of deep dive and try and make a distinction. Yeah. So now let's quickly move to our fourth example, and let's see how that will work out. A comes home drunk, hurls abuses at his father. Father calls out to his other son. The other son arrives and hits his brother with a small axe twice on the head. The deceased dies. So question here is, what will be the offense and what will be the punishment? So let's take a few minutes for this and try and answer this. And again, do the same analysis, 299, 300, the exception under 300. All right. So again, this is, I see some answers coming in. So again, this is straightforward, but again, helps us apply. So now this was a case where exception 1 of section 300 was applied. There was grave provocation by A. So the court held yes, that there was sudden and grave provocation by the deceased, and therefore the case would fall under exception 1, and the punishment would be under section 304 part 1, and try and reason it out as well. So here you'll see that the accused had no intention to kill. Again, what's important to see is to see his intention. Did he have any premeditation? There was no premeditation by the other son to kill his brother. So the court took note of that. Now the accused hits his brother with an axe. So again, axe is a dangerous weapon. So again, intention could be imputed to you. But what the court noticed in this case was, this was, I think, a case from Himachal Pradesh. So the axe was had a local usage. It was called tobru. So what the court noticed, and why this is important, court noticed that a tobru, which is like a small axe, was a weapon which was something which was very easily available in that part of the hills. So not something which the accused brought with him to show that he had intention to kill his brother. It was something which was lying there. He picked it up and under sudden and grave provocation attacked his brother. So therefore the conviction was under section 304 and not under 304, not under 302. So I hope this is also clear as far as these exceptions are concerned. And as far as the analysis is concerned, when you're doing, you always look at, so to decipher intention, intention is very important in murder matters. So you look at the weapon, the kind of weapon, what part of the body the blow was given, the amount of force. Then you'll see whether it was in a sudden fight or a quarrel. You'll see whether it was premeditated or not. You'll also see whether there was any motive, any animosity. You'll see whether there was any grave and sudden provocation, whether it was done in the heat of passion. So you'll run through the whole gamut of 299, 300, and the exceptions. You'll also see the exceptions under these exceptions, whether the person has taken any undue advantage, whether he's acted cruelly. So undue advantage would be multiple blows or continuing to attack. So all these are fact specific, but if you sort of do this analysis that we have discussed, I think it will bring you to a point where you will be very close to the answer. And again, each matter differs from facts of each matter differ, and the way the courts deal with it also, you'll have to see. But I think that will sort of help you come to a basic analysis. Now I want to very quickly, in the last couple of minutes, I think there were some questions as to the source of this chart. I think we had given the citation last time. If you can note the source of this chart, the 299 300 chart, you'll find that in multiple judgments. But look at 2007 14 SCC 588. That sets out the distinction between culpable homicide and murder. That's where you'll see the chart. Look at all. So again, 2007 14 SCC 588. Also look at 2005 and 9 SCC 650. That also draws out the distinction between murder and culpable homicide, again with the comparative table. For illustration 2, the judgment is 2004 12 SCC 269. For illustration 2, the judgment is 2004 12 SCC 269. For illustration 3, the judgment is 2003 10 SCC 472. 2003 10 SCC 472. For illustration 4, the judgment is 2012 13 SCC 663. That's an important judgment dealing with exception 1. So I would encourage you to read that. For exception 4, you may note down another judgment, 2008 17 SCC 170. Again, for exception 4, 2008 17 SCC 174. This deals very nicely with the concept of exception 4. As far as intention is concerned, I found 2011 2 SCC 123 to be very helpful. 2011 2 SCC 123. And we also last time pointed out Virsa Singh. That's another landmark judgment, which I think you should all read. That is AIR 1958, Supreme Court 464. Yeah, so I think if you have these 5 or 6 judgments. If you go through these 5 or 6 or 10 judgments which we have discussed, I think the basics will sort of become clearer and will help you. Um,
Shakil, if you
I
have the
don't
list
know if
of the cases with the citation, is it typed or there is any?
um,
If you can share it on
I
the
don't
screen.
have it separately, but I can, yeah, I can share it with you maybe in part 3 when we do.
Yeah, we can
Um,
give them the
and
list.
and maybe at the end of part, yeah, maybe at the end of part 3 we share a list of these judgments so that everybody has these judgments and the citations.
So last time
And
we
then
last time we asked them to read Virsa Singh, and hopefully those who are
yes,
repeatedly are attending this webinar, they might have benefited. So if you can just give them one or two citation which you would
yeah, so the ones that I gave out today, if
really,
we can all read those again, and maybe we'll just spend 5 minutes or 10 minutes on in session 3 just to see if there's anything, um, any pressing questions as far as 299 and 300 are concerned. And then I think in the next session, Charu, we'd like to cover the other statutory defenses, like insanity, the right of private defense. We'll also like to try and cover common intention, common objective, and conspiracy. So section 34, 149, 120B. We'd like to cover that. I think that will be for session 3, because I think now at least the basics are in place, hopefully, and now we can progress to even the finer aspects of common intention, common objective, and the other defenses. And again, we'll keep some time for clarifying 299, 300, because the more we read the section, the more sort of examples we see, the more judgments we read, it keeps getting better. So we will continue doing that. Um, and I'm happy to take some questions, but I did try and look at all the questions that were coming in to try and answer that while we were waiting for the answers. But if there's anything that the viewers would like us to cover in the next session, that also they can message in the next 1 or 2 minutes. We can sort of tailor our next session around that as well. But that's what we are thinking of for the third session.
okay. And since this video is available live on the YouTube also, it will be there. So if, when you can share the list of authorities with me, we can put it there in the comment section and people can go.
Yes, that's a good idea. That's a good idea.
The next time we will make a list of the cases that we would like them to read. A
Sure,
consolidated list for part 1, part 2, and the others also.
sure.
So I think this is it. I would just like to share our website also with the viewers because we are trying to, just a minute. I'll just share my screen also. This is just to share our work that we are doing. This is ebclearning.com. As I have told you in the beginning that this is e-learning initiative of the Eastern Book Company, the leading law publishers here. And so I'll just show you some of the courses and some of the talks that we are doing. There's a lot in offering also. So just a minute. The website is loading. Just give me a minute. So as you can see, we have done large number of courses on the ADR space. In the ADR space, we have got two courses on arbitration and one on mediation. We are already covered some case laws on the arbitration, the leading cases, and we will be uploading them soon. Then we have some courses on the banking practice. This is very important if you are a lender or from the perspective of the banks. Then some courses on the careers in law, And this is, we have got an initial course on the competition law, which deals with the economics of the competition law. Our consumer protection course, it is it is covers the latest consumer protection act. It covers in detail the essentials of it as well as the practical aspect of that. So there are two courses, and then we do have a talk with the author. In contract law, there are two courses which will be dealing with the essentials as well as with the drafting of the contract law. Then in the criminal law, we have got a course on criminology, which is very rare to find. And this is by a guy who's done a course in criminology from Oxford. Then some courses or entrance exams, we are working more on this. And then on insolvency and bankruptcy, we have got 7 courses. And if I can take you, we have developed a path for the insolvency and bankruptcy courses. So this is a path. This is a learning path which we have made for you. So we starts with the basics of the insolvency IBC. We starts with the essentials. Then we go on how to file an insolvency case. Then valuation is becoming something very important, something very critical. So we have got a whole course on how to do valuation, even on the basics of valuation. So even as lawyers, we are supposed to know and understand that how the valuation is important, right? And then we do have a course on negotiable instruments act, on the check bounce we have. And we have got a very niche course on the sports law, on creating privacy policy. And we have a one of its kind course on law and psychology essentials. So this is something which I found it very fascinating to go about. And for the law students, we have a course on the essential skills for the legal profession. So this course will tell you how, as a young lawyer or as a law student or as an intern, you have to conduct yourself, how to do research, how to manage the docket, how to dress appropriately. So all the basic things are being told there. Then we do have a course on due diligence. This is a course which will take you on the essentials of the due diligence, and we are developing an advanced course on the same as well. Uh, then we do have various talks. In the talks, we have talks with Ram Jetmalani sir. We have talked with N.R. Madhva sir. We have talked with Raju Ramchandran sir. And there are upcoming talks with Salman Khurshid sir, with KTS Tulsi sir, and many more. And we try to cover the latest topics as well. So GDPR was an issue, so we covered GDPR and how to comply with the same. So this is all that I can show you about our website. And of course, you can go and visit our YouTube channel, which is youtube.com/c/EBC learning. So all our webinars you will find available there. So this is all about us. Stay safe. And Shikil, if you would like to give them the next tentative date for the part
Uh,
3.
I think we can have it in a couple of weeks. So not the next Saturday, but the following Saturday.
Fine. So, and in the meantime, we will, in the comment section of this video, I will be sharing the list of the authorities that we think that you should read. Right? You will be sharing with me, and we can
Yes, I'll share it with you. Yes.
So thank you everyone for your time and for attending this webinar. Thank you, Shikil. Right.
Thank you so much for the opportunity. Thank you.
Thank you.
Bye.
Stay safe. Bye-bye.